Hello students, in continuation with our discussion on the most probable topics in the mains 2022, today I am going to talk about the anti-defection law. You all know about the context of the video, that is in the Maharashtra, that there has been a separate camp within the Shiv Sena and later on he became the chief minister of the Maharashtra. So we will talk about the constitutional angle associated with this particular episode whenever I will talk about that why there is a need to change the anti-defection law. But before that, in this video, I will also talk about the benefits of anti-defection law along with the controversy and the recommendation given by the Supreme Court and different committees. Okay? But before discussing these three important parameters, I just want to talk about the historical context of anti-defection law. So what has happened in 1967, there is a rise of syndrome in the political discourse of India, that is IAS and Gayaram. Gayaram was basically a MLA who had changed his party thrice within the same day in 1967. Thereafter, a lot of deliberation and the discussion has started on the floor of the House, and that has resulted into the 52nd Amendment Act, and the result is anti-defection law. This is the historical understanding of the anti-defection law, which can be used in the introduction itself. However, the another way of introducing the question on the anti-defection law is constitutional based introduction, and there you can talk about the amendment and the significance of ADA. So now in the next slide, I just want to talk about what is the significance of anti-defection law. The very first thing, that it promotes loyalty, and whenever there is a loyalty amongst the cadres of the political party, it ensures party discipline. This is the very first benefit of anti-defection law. Then the second, it also checks the corruption, because we know horse trading going on the floor of the House. Then the third, it brings stability in the government. It brings stability of the government. And whenever there is a stable government, it ensures the faith of a common people in the democracy. It ensures the faith of common people in democracy. Because when the members of the political party or when any MLA or MP defects, then it is not only about defection. It is about his representation of a particular constituency, why the people have voted him, either an MLA or MP of that particular constituency. Maybe it is because of his individual persona, or it is because of his political party to which he belongs. So whenever he is defecting, he is basically breaking the promise of the people in the constituency. So this is the reason that we need anti-defection law. Now we will just talk about that why we always talk about that there is a requirement of the change in the anti-defection law. The very first situation, or you can actually, whenever you are writing your answer, you can bring a segmentation in your answer by mentioning the subheadings. I know everybody who is watching this video and who is not watching this video knows each and every fact associated with the anti-defection law. But whenever you are writing your answer, what I felt looking into the number of answers, that you are not following a particular flow in your answer. Therefore, the information what you have can be clubbed under these parameters. Now, defection versus dissent. Here, we know that when anti-defection will apply. For example, if you are a member of a political party and you are voluntarily giving up the membership, or whenever you are not obeying the directions given by the whip, then anti-defection law will apply on you. So basically, dissent, there is no any scope of dissent in the political party. Whatever directives have been given to you by the party whip, you must follow that. Therefore, The dissent is the life, or you can say dissent is the breath of the democracy. And this anti-defection law is antithetical to the idea of dissent, which is the cornerstone of any democracy. Now, the second is delay in disqualification. It has been observed, and you also know, that there is no any fixed timeline for the speaker to decide on the matter of disqualification. Therefore, it has been realized in Haryana, it has been observed in Telangana, Andhra Pradesh also, and it has been observed in Karnataka also, that the speaker is taking too much time in deciding the matter of disqualification. The third is recurrent merger versus split merger. It means that there is an exception to the anti-defection law, that whenever 2/3 of the party members are splitting and joining another political party, then anti-defection law will not apply. Then anti-defection law will not apply. Clear? Now, today 1/3 are leaving the party, then next day 1/3 are leaving the party, then this is called recurrent merger. So now, if the speaker is taking a time in deciding the matter of disqualification, so for example, today 10 members are leaving the party, tomorrow 15 are leaving the party, day after tomorrow 20 are leaving the party, then this is called recurrent leaving the party, and they are joining to the another party later on, then it is a recurrent merger. Whether it will be counted as 2/3 merger, or it should be counted as 10, 15 and 20 members. This is the problem. Because the speaker is delaying in the disqualification, therefore, some of the members are leaving today, some of the members are leaving tomorrow. Then whether the anti-defection law will apply on these members or not, or the speaker is waiting that once the 2/3 majority or once the 2/3 members will leave the party, then I will think about the disqualification. So, recurrent mergers versus split merger, it has been observed in the Andhra Pradesh, and this is, you can say, a loophole in the law which is being exploited by the political members. Now, the next is voluntarily giving up the membership. So, we all know that the voluntarily giving up membership leads to anti-defection law, or leads to the application of anti-defection law. But the question arises that if I am leaving the party, then do I need to resign from the party or not? So basically this question has come in Ravi Nayak case before the court. So in Ravi Nayak case, the court has said that there is a difference between voluntarily giving up the membership or resignation. There is a difference between this, and voluntarily giving up membership has a wider connotation. So therefore, again, it is very complex situation that whether you will accept the term voluntarily giving up membership after giving resignation of the member or before giving the resignation of the member. So this has been looked into the Ravi Nayak case by the court itself. Next is ambiguity with Article 191. So if you will read Article 191 clause 1 clause E, then it talks about the disqualification, and along with the disqualification of the member, it talks about that once you are disqualified from the house, you cannot become the minister of the house. But there is an ambiguity in this particular article, and therefore this matter went to the court in Srimant Balaji case. And in this case, court has said that once you are disqualified, or basically once you have defected from a political party and the tenure of the government is of 5 years and you are defecting after 2 years, then you cannot become the minister from that political party. That is very simple. But whether your defection means the disqualification for the remaining 3 years of the tenure of the government or not, Then the court has said, just try to understand it from a simple example, that the tenure of the government is of 5 years. You have defected the party after 2 years. And once anti-defection law is applied on you, you are disqualified. But now, if you contest the by-election, just I am giving a situation. Now, if you contest a by-election and then again you won from that constituency, then whether you can become the minister or not. This is the next question. So now in Srimant Balaji case, it has been said that it is possible. It is possible. So once you are disqualified from being a member of the house, but you have defected from the party, contesting from the seat of another political party, winning from there, coming again onto the floor of house, then you will become the member of the house again, no matter you have defected it earlier. So this is the meaning of ambiguity with the article 191. Now, before recommendation, I just want to talk about what has happened in case of Maharashtra. So in case of Maharashtra, if you will see, then I will say that broadly there are two issues: merger and role of deputy speaker. Why I am talking about deputy speaker when everybody knows that the speaker is looking into the matter of disqualification under the anti-defection law? The reason is the post of a speaker is vacant in Maharashtra Legislative Assembly and deputy speaker is performing the function of a speaker. First thing I want just to make clear to you. Now merger. So we all know that 2/3 merger is possible. So Eknath Shinde has more than 2/3 members with him. Clear? Now there is an ambiguity. Why there is an ambiguity? Because he is a member of Shiv Sena. He has a 2/3 majority. He has he is constitutionally right. If he is defecting from Shiv Sena and joining any political party, then it's fine. Anti-defection law will not apply on him because he has 2/3 members. But in that case, what Mr. Eknath Shinde has done, that he has formed a separate camp within the Shiv Sena, and replacing the Uddhav Thackeray from the entire, you can say, from the history of the politics, I will say. Okay, that can be an extreme condition or that can be extreme statement, but I will say that whenever he is forming a separate camp within the Shiv Sena, but not joining any political party, then whether the anti-defection law will apply or not. Some of the constitutional experts are telling that this is a loophole in the law, and he is exploiting that loophole. 2/3 majority he has. He has 2/3 majority, but not joining any political party and not leaving his original party, that is Shiv Sena. So he has created a camp, and therefore PDT Achari, a constitutional expert, is telling that this is a violation of anti-defection law. Okay, this is his view. Okay, I am not going and I am not here to interpret each and every views on anti-defection law. I am just telling that what is the controversy and what is the loopholes in the law. The second is deputy speaker. Now, you all know that the speaker is taking an issue of the disqualification. Now here deputy speaker is doing each and everything. But here what is happening in Maharashtra Legislative Assembly, that already no confidence motion is passed against the deputy speaker, or you can say, better to say, a resolution to remove the deputy speaker is already on the floor of the house. So now in this case, can deputy speaker take the matter of disqualification? So to understand this situation, you will have to refer Arunachal Pradesh case. You will have to refer to the Arunachal Pradesh case. Okay. In this particular case, the court has said that whenever there is a resolution for the removal of the speaker is going on the floor of the house, he does not have any power to take the decision on the matter of disqualification. So again, this is one of the controversy. So these are the two controversies associated with the new government which has been set up recently. Clear? Now, what are the recommendations? There is a recommendation from Dinesh Goswami committee. There is a recommendation from Dinesh Goswami committee. And this committee says that anti-defection law should not apply when the party member is not following a whip in the normal circumstances. However, the party member should follow the whip in the extraordinary condition like passing the budget and all. Otherwise, in the normal circumstances, the anti-defection law should not apply on him. Basically, this committee is recommending for giving an scope for a dissent, which is the founder or which is the foundation stone of the democracy. Now, Supreme Court has also said that the tribunal should be constituted to decide the matter of disqualification, where a speaker is doing the quasi-judicial function. And also, the timeline of 3 months should be fixed for the speaker to decide on the matter of disqualification. There should not be a delay in the matter of disqualification. So this is all about the anti-defection law. Maybe the question can come on anti-defection law that anti-defection law has served its purpose but now outlived its utility. For example, just I want to give you an example. For if I frame the question here, if I frame the question, just give me a second. Okay. So here everywhere I have written, that's not an issue. So if I frame the question like this, anti-defection law has served its purpose but outlived its utility. Comment 10 marks. So here you just need to talk about the significance of ADL, and then you will have to talk about the controversies in the series which I have discussed with you by forming a subheading and then discussing about that particular point. Clear? So now, if you want to have the write-ups on anti-defection law, you can refer to our PDF, Polity PDF on our Telegram channel, IAS 360. On our Telegram channel, IAS 360. Clear? So that's all about today's video. Again, I will come with a new video with the new probable topic. Thanks to all of you.